Welcome back to LexTalks, Legal Topics Simplified. We're all about making law school a little less overwhelming, right?
Less overwhelming and a lot more interesting.
Absolutely. And today we're going to be tackling a topic that's super relevant for any aspiring lawyer.
You guessed it, administrative law.
Now, I got to admit, when I first heard about administrative law, I thought it was going to be kind of a snooze fest. Yeah. All about boring bureaucratic stuff.
Yeah, it doesn't exactly have the same ring to it as, say, criminal law or constitutional law, does it?
Not quite. But once I started digging into it, I realized just how impactful it is. I mean, it touches practically every aspect of our lives.
It really does. And it's way more interesting than people give it credit for.
So let's start with the basics. What exactly is administrative law? How would you explain it to someone who's not in law school?
Well, think of it this way. Every day we interact with government agencies without even realizing it. Like when you're grabbing a coffee at your favorite cafe, the FDA is making sure that milk is safe to drink. Or when you're flying across the country, the FAA is keeping that plane in the air.
Oh, yeah. I never thought of it like that. So those agencies are everywhere, huh?
They are. And administrative law is basically the set of rules and principles that govern how those agencies operate. It's like their rule book, making sure they're using their power properly and not stepping on anyone's toes.
Okay, so it's about keeping those agencies in check, making sure they're not just running wild.
Exactly. You see, administrative agencies have a ton of power. They can make rules, enforce those rules, and even judge disputes that arise under those rules.
Wow, that's a lot of power for unelected officials. No wonder we need a whole body of law to regulate them.
Exactly. And that's where administrative law comes in. It sets limits on that power, ensures transparency, and protects individual rights.
So it's like a system of checks and balances for the administrative state.
You could say that. Think of it as the legal framework that balances the need for government regulation with the protection of individual freedoms.
Okay, I'm starting to see the bigger picture here.
Yeah.
But before we get too deep into the weeds, can you give us a little historical context? I mean, how did this whole field of administrative law even come about?
Well, it's a long and winding story, but essentially, administrative law is a byproduct of the modern welfare state. As the role of government expanded in the 20th century, particularly during the New Deal era, we saw a huge surge in administrative agencies.
So basically, the government started doing more, and that created a need for more rules.
Exactly. And those rules became the foundation of administrative law.
Makes sense. So we have this explosion of government agencies, and administrative law emerges as a way to manage all that new power. But why couldn't the legislator just handle all of this? I mean, isn't making laws their job?
Technically, yes, but imagine Congress trying to write detailed regulations for every single industry and every potential hazard.
Yeah, I can't see those folks agreeing on what kind of pizza to order, let alone complex regulations.
Exactly, it would be a logistical nightmare. Plus, legislators aren't experts in every field. You need specialized knowledge to create effective regulations for things like, say, nuclear power or aviation safety.
Okay, so they needed help experts who could delve into the nitty-gritty details.
Right, and that's why administrative agencies were created. They're staffed with specialists who can focus on specific areas and develop rules that are tailored to those complexities.
So it's kind of like a division of labor. Congress sets the broad goals, and the agencies fill in the blanks with the technical stuff.
You got it. But of course, there's always a risk when you give unelected officials so much power.
That's what I was thinking. What's to stop those agencies from abusing their discretion?
That's the million-dollar question, and that's exactly what we'll be exploring in the rest of our deep dive.
Ooh, sounds juicy. I'm ready to dive in.
Let's do it. So let's talk about this whole abuse of discretion thing. It's a big deal in administrative law.
Yeah, it sounds kind of ominous, doesn't it? Like some bureaucrat sitting in their office just making arbitrary decisions.
Well, it can definitely be a concern. You see, agencies have a lot of leeway when it comes to interpreting and applying the law.
Right, like they're not just robots following a script.
Exactly. They have to make judgments, weigh different factors, and consider the specific circumstances of each case.
Okay, I can see how that would be necessary. But how do we make sure they're not abusing that power? I mean, what's to stop an agency from, say, favoring their buddies or punishing their enemies?
Well, that's where judicial review comes in.
Ah, our old friend, the judiciary. Always there to keep things in check.
That's right. If someone believes that an agency has acted unfairly or overstepped its bounds, they can challenge that decision in court.
So the courts are like the referees, making sure the agencies are playing by the rules.
Exactly. And they have specific tests they use to determine whether an agency has abused its discretion.
Ooh, tests. Tell me more.
Well, for instance, courts might look at whether the agency considered all the relevant factors when making its decision.
So they can't just ignore evidence that doesn't fit their narrative, right?
Right. They also have to make sure their decision is supported by substantial evidence.
Meaning they can't just pull their decisions out of thin air. They have to have some solid grounding for them.
Exactly. And they have to follow proper procedures, like giving people notice and a chance to be heard before making a decision that affects them.
So it's not just about the outcome, it's about the process too.
Absolutely. Administrative law is all about ensuring that agencies act fairly, rationally, and within the bounds of the law.
Okay, I'm getting it.
Hmm.
But I'm still a little fuzzy on the whole constitutional law versus administrative law thing. They both deal with government power, right?
They do, but they operate on different levels. Think of it this way. Constitutional law is like the foundation of a house.
Okay, I like where this is going. So constitutional law is the base upon which everything else is built.
Right. It sets out the basic framework of government, guarantees fundamental rights, and establishes the limits of government power.
Got it. So where does administrative law fit into this house metaphor?
Well, think of administrative law as the walls, the roof, the plumbing, the electrical system. It's all the stuff that makes the house functional and livable.
Ah, so it's the practical application of those constitutional principles.
Exactly. Administrative law fills in the gaps, providing the details about how those broad constitutional principles are actually implemented in the real world.
I see. So constitutional law is the blueprint, and administrative law is the construction manual.
You got it. And just like you can't build a house without a foundation, administrative law can't contradict or undermine the Constitution.
So it's like a hierarchy, with constitutional law at the top.
Exactly. Administrative law operates within the boundaries set by constitutional law, but it still has its own unique set of principles and doctrines.
Okay, I think I'm starting to see the distinction. But I'm a visual learner, so could we maybe, like, put this in a table or something, just to really hammer it home?
Sure, a table's a great idea. Let's break it down side by side. So first, we have meaning. Constitutional law, as we said, is that foundational document. It's the body of law derived from the Constitution itself. Administrative law, on the other hand, is focused specifically on those government agencies we were talking about. It's all about their powers, their procedures, how they make decisions.
Okay, so constitutional law is big picture. Administrative law is more focused.
Exactly. Now let's look at class. Constitutional law is like the main category, the overarching legal framework for the entire country. Administrative law is a subset, a specific area within that larger framework.
Okay, so it's a category within a category.
You got it. Now, what they deal with. Constitutional law, it's all about the structure of the state, how the government's organized, the powers of different branches, that sort of thing. Administrative law is more concerned with the functions of the state, how those branches actually work in practice, particularly those agencies.
So it's the difference between theory and practice.
You could say that. Now, superiority. No surprises here. Constitutional law is top dog. It's the supreme law of the land, the ultimate authority. Administrative law, gotta play by the rules set by the Constitution.
Okay, makes sense. It's like a chain of command.
Right. And finally, type. Constitutional law, it's mostly theoretical, setting out the grand principles, the big ideas. Administrative law gets down to the nitty-gritty, the nuts and bolts of how things actually work on a day-to-day basis.
So it's more practical, hands-on.
Exactly. So there you have it, constitutional law and administrative law, side by side.
Wow, that table really helped to clarify things. Thanks for indulging my visual learning needs.
No problem. Glad it was helpful. Now, we've been talking a lot about judicial review, how the courts can step in and make sure agencies aren't abusing their power.
Right, the judiciary to the rescue.
But they're not the only ones keeping an eye on things. The other branches of government have a role to play too, through legislative oversight and executive control.
Oh, right.
Yeah.
Checks and balances in action. So what exactly does legislative oversight look like?
Well, Congress has the power to create and abolish agencies. That's a pretty big stick right there.
Yeah, no kidding. If an agency steps out of line, Congress can just shut it down.
They can. And they also control the purse strings they set the agency's budgets.
Ah, the power of the purse. That'll get their attention.
It will. Plus, Congress can hold hearings, call agency officials to testify, grill them on their decisions, all very public, very uncomfortable.
So Congress can make life pretty difficult for an agency if they're not happy with what they're doing.
They can. And then there's the executive branch, with the president at the helm.
Right, the big boss. So how does the executive branch keep those agencies in line?
Well, the president appoints the heads of many agencies, so they can put people in place who align with their policy goals.
Stacking the deck, so to speak.
In a way, yes. And the president can issue executive orders, which are basically directives to agencies telling them what to do.
So they can give direct orders, cut through the red tape.
Exactly. Plus, they can fire agency heads who aren't following their lead, so they have a lot of control.
Wow, it sounds like a lot of power struggles going on behind the scenes.
It can be, but that's the nature of checks and balances. It's all about ensuring that no one branch of government or any one agency becomes too powerful.
Makes sense. So we've talked about judicial review, legislative oversight, executive control. Is there anything else we need to know about how administrative agencies are kept in check?
Well, there's one more important concept we need to discuss, and that's natural justice.
Natural justice. It sounds kind of philosophical, doesn't it?
It is, in a way, but it also has very practical implications for administrative law.
Okay, I'm intrigued. Break it down for me.
Natural justice is basically the idea that everyone deserves to be treated fairly by the government, including by administrative agencies.
Okay, so it's about fairness. That makes sense.
Yeah.
But what does that actually look like in practice?
Well, there are two key components to natural justice. First is the right to a fair hearing. This means that if an agency is going to make a decision that affects you, you have the right to know what the case is against you. You have the right to present your side of the story, to offer evidence, to challenge the agency's evidence.
So it's kind of like having your day in court, even if it's not an actual courtroom.
Exactly. And the second component is the rule against bias. This means that the person making the decision has to be impartial. They can't have a personal stake in the outcome, and they can't be influenced by irrelevant factors.
So, like, if the decision maker is your best friend or your worst enemy, that wouldn't exactly be a fair shake, right?
Exactly. These principles of natural justice help to ensure that even though agencies have a lot of power, they're still obligated to exercise that power fairly and justly.
So it's like a safeguard against arbitrary or biased decision-making.
Precisely. Natural justice is a cornerstone of administrative law, and it plays a vital role in protecting individual rights.
Okay, I'm really starting to see how all of this fits together, but I have to ask, are there ever situations where these principles of natural justice might be limited or even suspended? I mean, are there exceptions to the rule?
There are, but they're pretty rare, and they have to be justified by really compelling reasons, like think national security or a public health emergency. Sometimes you got to move quickly, and you can't always follow all the usual procedures.
Like in a pandemic, for instance.
Exactly. But even in those situations, the courts will still scrutinize those exceptions very carefully. They want to make sure that natural justice isn't being sacrificed unnecessarily.
So it's like, yeah, you can bend the rules a bit if you absolutely have to, but you better have a really good explanation.
Exactly. Okay, ready to tackle another big concept in administrative law.
Hit me with it. I'm feeling pretty confident now.
All right, let's talk about delegated legislation.
Delegated legislation. Sounds kind of fancy. What's that all about?
Well, it's a bit of a mouthful, but it's basically the process where legislatures give administrative agencies the power to make rules and regulations.
Hold on a second. You're telling me that agencies can actually make laws? I thought that was Congress's job.
It is, but think about it practically. Congress is busy dealing with all sorts of big picture stuff. They can't possibly create detailed rules for every single aspect of our lives, especially in areas that are really complex and technical.
I see your point. Like, I can't imagine Congress trying to write regulations for, say, the pharmaceutical industry or something like that. They'd be there for years.
Exactly. They just don't have the time or the expertise. So what they do is they delegate some of that rulemaking power to the agencies that specialize in those areas.
So it's like a division of labor. Congress sets the overall policy, the big goals, and the agencies figure out the nitty-gritty details of how to make it happen.
You got it. Think of it like this. Let's say Congress passes a law saying, hey, we need to protect endangered species.
Makes sense.
But that law is just a broad statement of intent. It doesn't actually tell anyone what to do specifically. So Congress might say to the Fish and Wildlife Service, okay, you guys are the experts on this. Go ahead and create some specific rules about how to protect these endangered species.
Oh, so they give the agency the power to create the actual regulations, the on-the-ground rules that people and companies actually have to follow.
Right. And those regulations have the force of law, just like if Congress had passed them directly.
Okay, that makes sense in terms of efficiency and expertise, but isn't it a little risky giving unelected officials that much power? What's to stop them from abusing it?
Well, first of all, Congress doesn't just give them a blank check. They set limits on the agency's rulemaking authority. They say, okay, you can make rules about this, but not about that.
So they put some boundaries around it, like drawing a line in the sand.
Exactly. And second, just like any other agency action, delegated legislation is subject to judicial review.
Right. The courts can step in and make sure the agency isn't going rogue.
Exactly. So if someone feels like an agency has overstepped its bounds or created a rule that's unfair or unconstitutional, they can challenge it in court.
Okay, that makes me feel better. So it's a system of checks and balances again, even when it comes to rulemaking.
Right. It's all about striking a balance, giving agencies enough power to be effective, but also ensuring that they don't abuse that power.
Well, I think we've covered a ton of ground today, from the history of administrative law to the concept of natural justice. We've really explored the ins and outs of this fascinating field.
We have. And I hope our listeners now have a much clearer understanding of how administrative law works and why it's so important.
Me too. I know I certainly learned a lot. And to our listeners, if you're still feeling a bit overwhelmed by administrative law, don't worry.
It's a complex subject, but the more you engage with it, the more it'll start to make sense.
And remember, administrative law is all around us. It affects our daily lives in countless ways, from the food we eat to the air we breathe to the medications we take.
So pay attention to those agencies. Understand their powers and how they make decisions. And most importantly, don't be afraid to speak up if you feel like your rights are being violated.
Well said. And on that note, thanks for joining us on this deep dive into administrative law.
It's been a pleasure.
Be sure to subscribe to LexTalks for more deep dives into the world of law. We'll be back soon with another exciting topic, breaking it down and making it easy to understand. Until then, happy studying.